Good evening, Mr. Williams.
Howdy.
How are you?
I'm fine.
I'm glad that we're back to continue our conversation and we're able to meet with the minds to come back to a part two. Are you ready to get started where we left off?
Yes, ma'am.
Okay, so I believe the last real question that I asked you was about the pen register and if you could explain to me what it was. And you told me they were asking for extended time to intercept communications. And we didn't get a chance to get into the phone calls that were collected during that time. So there's a list of phone calls to and from your phone. Telephone number 504-259-0692, Terrence L. Williams. Incoming and outgoing two phone numbers. So the first one listed is phone number 504-259-6142 with 168 calls to and from that number, and the last call being January 17, 1998. The subscriber for that number is Donald A. Dyer, 2623 Mendez Street, New Orleans, Louisiana. The next number listed is 504-259-2827 with 123 calls, the last call being on January 18, 1998. And the subscriber for this line is Kenan L. Bradford, 1723 Joliet Street, New Orleans, Louisiana. The next number listed is 504-259-2060 with 165 calls, last call being on January 18, 1998. The subscriber for this line is Daniel D. Jones, 425.
Excuse me, that's Danielle.
Oh, Danielle. They didn't put the E on here. My apologies. Danielle D. Jones, 425 South Alexander Street, New Orleans, Louisiana. The next number listed is 504-891-3782 with 83 calls, last call being on January 17, 1998. The subscriber for this line is Christopher J. Williams, 2807 Willow Street, Apartment A, New Orleans, Louisiana. The next number listed is 504-895-4584 with 88 calls, with last call being on January 18th, 1998. Terrence L. Williams, 2807 William Street, Apartment A, New Orleans, Louisiana, is also listed as the subscriber to that number. The next number listed is 504-821-1962 with 41 calls. Last call being January 16, 1998. The subscriber for this line is Darrell B. Moore, 3035 Bank Street, New Orleans, Louisiana. The last number listed is 504-895-6144 with 14 calls. Last call being on January 17, 1998. And the subscriber for this line is Shantae Levis, I assume Levis, 2807 Willow Street, Apartment B, New Orleans, Louisiana. So, being that this pen gave us a list of calls, the amount of calls, and the subscribers for the calls, would you be able to give me insight on, is this what the detectives and investigators used as their main evidence to establish the continuing criminal enterprise charge against you? Or did they basically try to trump that up from linking your prior history with their surveillance?
While my phone was tapped, those were the people that would call me the most. And if they would say certain things, if we would mention anything dealing with a criminal act, that's who the feds target. But like Kenan Bradford, that's a greedy man. He deceased now out of Pigeon Town. How he almost got caught up into my conspiracy. One night I was going to rob this guy out in Franklin or something, and he had some crack, and I didn't. No, no, no. Yeah, I didn't like crack. So I hit Greedy Man. I was like, yo, I'm about to go hit this, like a half a key. It was a quarter barrel or a half a key or something like that, but it wasn't much. So I was like, look, I'm about to go jack the P right quick. You want this? He was like, it's hard or soft. I was like, man, it's soft. I mean, hard. Like, nah, I'm good. I'm going to pass on. I like to do my own thing. So by him and I talking, the feds kind of keyed it on him. That just like with Danielle, she have a daughter with mosquito. Um, Shantae have a son with Sweet Pea. Sweet Pea was my neighbor. So, quite naturally, the neighbor gonna call, or if we not around, he gonna handle the business, whatever the case may be. But they was never locked up on my. Chris was never locked up on my case. Greedy Man was never locked up on. Keenan Bradford was never locked up on my case. Danielle Jones never. And Shantae, they was never locked up on my case. But the feds was listening to them. The feds really didn't care. They just made some papers, but they really wanted Blabber, Hot, myself, and Bryce. Though we were the main ones that they really wanted. But so happened by my phone being tapped and they called my phone, they just got caught up in the shuffle.
Okay. So beneath the phone calls listed is some explanations about how they feel that each subscriber is tied to the phone based upon addresses that was given during the time that each person was arrested before. So, and those are the addresses that I listed during the telephone numbers.
Mm-hmm.
So basically what I'm reading is that because you or Christopher or Danielle or whoever had been arrested before and given this address, and them intercepting through PrimeCo and PrimeCo saying, well, Terrence is the subscriber for this phone, Danielle's the subscriber for that phone, that they could take and put whatever conversation on whomever was on that phone, even though they can't pinpoint who's using my phone or Terrence's phone or Danielle's phone at a certain time, but just because they're law authority and they have orders, they can really just take what they want from these conversations and apply it to whoever, because an address is on file from a prior arrest, and PrimeCo says that this person subscribes to the phone, but it could be my brother, my sister, or anyone else.
Correct.
Wow. Okay. So going forward with the affidavit, it says, based upon your finest training and experience, as well as the experience of other special agents of the FBI, and based upon all the facts set forth herein, it is your finest belief that interception of wire communications is the only available technique that has a reasonable likelihood of securing evidence necessary to prove beyond a doubt that Terrance L. Williams, also known as Gangsta, Christopher J. Williams, Darrell B. Moore, a.k.a. Bryce, Donald A. Dyer, a.k.a. Blabber, Kenan L. Bradford, a.k.a. Greedy Man, first name unknown, last name unknown, a.k.a. Sweet Pea, and others yet unknown are engaged in above described offenses. Your fine is aware that although normal investigative procedures have been successful in initiating this investigation, these investigative procedures have been tried and failed, or reasonably appear to be unlikely to succeed in achieving all the objectives of this investigation, or are too dangerous to employ. So they're saying that they're here to prove beyond a doubt, but everything I've read up to now seems that they doubt what they have, and they're trying to get more proof, and they're trying to make sure that what they're thinking is correct. And for lack of a better way to put it, instead of doing something more that they could have more concrete proof on, they had like a hard on, or they just really were pressed to take you guys down, or more so take you down. Would you agree with that?
Yes. That part what you just read, was there a title? Because you kind of lost me. Was there a title?
Oh, okay. The title for this part of the affidavit is Failure of Normal Investigative Procedures, where we were talking about how the procedures that they had up to this point had failed.
Okay, so you say the name, the title for that for whatever you're going into now, it was called Failure of Normal
Yes.
Investigation Procedures.
Yes.
So right there answers your question that a lot of stuff, the way the feds work, how they would normally try to investigate a person, that didn't work for us because we was kind of on point.
Okay, yes, that's what I was asking. Yes, so that's
Right.
that's basically what I was thinking. Thank you for confirming it for me. So going further into the section on the failure of normal investigative procedures, it says CS1 has been able to purchase heroin directly from Terrance L. Williams. CS1 has also been able to consensually monitor and record conversations regarding heroin with Terrance L. Williams. However, CS1 has failed to identify all the conspirators, all the locations and money derived from the purchase and sale of cocaine, crack cocaine, and heroin, and all the locations where the cocaine and heroin are stored and sold. Your affiant believes that the interception sought herein will provide that information. So, would you like to speak there for me, Mr. Williams? Because I was going to say basically what you just said, that they keep reiterating how they have failed.
Well, what it was, usually when the informant moving on an organization, he or she gets in and try to find out as much as they can, like where the drugs being stored. Like we might be selling on Willow Street, but we might have our drugs hid on in the Circle in Claro, in someone's apartment. I might have the money hid on Magnolia Street. So it's the informant job to try to find out as much information as possible, so when the feds swoop in, they know where all houses, where all spots to go hit. But he wasn't that cool with me, so he wasn't going to be able to find out a lot of stuff, what I had going on, because he wasn't, one of the people I trust or that I hung out with.
Right. Okay.
Right.
So it goes further to say the PIN register data summarized in paragraph 10, supra, further suggests that the target telephone number is being used to facilitate Williams' heroin and cocaine distribution operation within the Magnolia housing development. So we just agreed that they keep stating how the investigations have failed, but then they go into suggesting again that you have an entire operation that they've yet to have any concrete evidence of that. It seems like a lot of hearsay, like the CS1 said, beyond what they recorded, but to the level of operation, it seems like it's all hearsay that you have this operation at this time. Is that correct?
Yes.
Okay. CS1 has stated that CS1 would be fearful for her or his life, and most certainly would be in a position of jeopardy if CS1's involvement with law enforcement authorities were known to Williams and his associates. In fact, Williams has discussed with CS1, Williams' brother, Christopher's attempted kidnapping and assault of a suspected police informant. Williams, although only 21 years old, has been arrested 22 times, including 5 times, for 5 different murders, and has pled guilty on 1 occasion to attempted second-degree murder. Williams has also been arrested, but not prosecuted for intimidating a witness. So, would you like to speak on that for me? Because when I read the charges on part 1, I didn't see the part about pleading guilty to attempted second-degree murder. It was like an aggravated assault that I read on. So can you elaborate on what they're stating here?
Yeah, that was it started from attempted murder. It was 3 of us that was locked up on that charge. Um, they tried to be slick too. There was my co-defendant Norris Crawford out the Methamphetamine Project. He had pled guilty. And how our state do, once you plead guilty, they ask you to testify before the court as to what you did, what happened on the day of the situation. So when Norris got on the stand, he pled guilty. I mean, he told him his name, stated his name, and he told the people that he did that I had nothing to do with it. So now they were just mad. They were trying to give me 99 years for that. They were just mad with me because, ma'am?
I didn't say anything. Go ahead, sir.
So they was mad with me because I didn't want to give up my co-defendant on the murder that they come got me from juvenile jail. They thought because they come got me from juvenile jail that I was going to cooperate against my co-defendant Walter Johnson, who's in Angola now. So they wound up dropping the murder in the armed robbery, but for the attempted murder, they dropped it down to aggravated battery. That's when I got the 10-year suspended sentence and the 5-year probation in 93, September 93. So it started out an attempt murder, but they dropped it down to aggravated battery for me to plead guilty to it. You understand now?
Yes, I do. Thank you for clearing that up for me.
Yeah, no problem.
So the affidavit goes on to state CS1 has advised that if relocated, he or she would be willing to testify at judicial proceedings. However, CS1 is unable to furnish information which would fully identify all of Williams' criminal associates or to fully define each associate's role in Williams' criminal activities. And as far as I'm reading, it seems that no one really could do that. So is that because it wasn't really an operation to identify these activities, and it was a collective of individuals that were friends and neighbors doing different things that fit their lifestyles at the time?
There you go, right there. Because Blabber was grinding by himself, I was grinding high. Everybody was doing their own thing. Like we was a family, but we was all hustling and grinding doing our own thing. But by me being a target, my phone tapped, so automatically I got the leadership role. So, of course, it was hard for the informant to find out who was what, like who was the lieutenant, who was the shooter, who was the person who bagged the dope, because we didn't have it like that. So all he knew, he used to come in there, get his dope, and get on out of there, stick and move. And then you know how you would say, huh? Got stuck in there on New Year's Eve, huh? It was hard to breathe, couldn't leave, huh? It was hard to breathe. So he was scared, you got to stick and move. But he wasn't too scared though. He wore that wire on me.
Yes, he did. Okay, going forward. Based on my experience and the experience of other special agents of the FBI, it is believed that interviews would not normally be successful regarding this type of criminal activity because the only persons knowledgeable about the contents of the conversations or transactions are the parties who are the direct participants and who are themselves the subjects of these investigations. Interviews with drug dealers and their customers are not generally productive because the individuals fear for their physical safety or because of their own culpability. Your client has met with Assistant United States Attorney Joseph Uzzolino and discussed with him the possibility of initiating a grand jury investigation into the illegal activities of Williams and his associates. So when I read that the first time, I'm like, you guys keep telling me you failed. You really don't have anything, and you went as far as to go and ask the United States Attorney to do a grand jury investigation. So I was like, it's still like a hard on just to get you, like they just had it out for you. Would you agree?
Of course. I was a young innocent man trying to make ends meet. But how the feds work, like if they hear you doing a lot of violent crimes, they're gonna do any and everything they can to get you off the street. So whether they got to cheat, if they feel like, okay, we got a little something, we know he's selling drugs because they know I sold drugs to the guy. So it's like, that's enough. Let's get him with that, and let's tack on all the other stuff and let the chips fall where they may. And if you don't have a good attorney, we don't know the law, so they just hit us with, oh, we're going to give you 100 years, we're going to give you this, you got to cop out, or we're going to go arrest your mother, we're going to go arrest this because your mother, we got her on the phone having a knowledge of one of your criminal activities. And that's what my co-defendant, Elton Patterson, was charged with. It was called misimprisonment of a felony, known of a crime and not reporting it. See, a lot of people don't know that that's a charge.
I didn't know it was a charge. That's heavy.
Yes, man. So if you got a man and he toting that fire, or if y'all, I don't know what you got going on, man, but if y'all wilding or he wilding, you know about it, you on the phone and he telling you, look, take them 50,000, put it over here, tell them, put that up, and you can go to jail for that. If you see somebody do a robbery or do a crime and you don't report it and you know about it, you can get in trouble for that.
Wow.
Misimprisonment of a felony.
That's a lot. Okay, so Assistant United States Attorney Joseph Uzzolino told your affiant that in his opinion, a federal grand jury would probably not be successful achieving the goals of the investigation for the following reasons. A, the subjects of the investigation, should they be called to testify, would most likely invoke their Fifth Amendment privilege against self-incrimination. B, it would be unwise to seek immunity for Williams or any of his associates. So it seems to me that the assistant U.S. attorney wasn't impressed at all with their presentation.
Right.
Would you agree?
Of course.
Okay. The affiant continued that surveillance within the Magnolia housing development was helpful, but due to lookouts, it proved to be unsuccessful. The streets that border the housing development also had posted lookouts. Additionally, Williams has been known to use a variety of vehicles, none registered to him, which makes it difficult to determine on any particular day what vehicle he might be driving. When physical surveillance is used in conjunction with electronic surveillance, however, the purpose of meetings and identities of participants often take on new significance and may constitute admissible evidence. Even the way that's worded to me is saying that they can assume and they can put things any kind of way that they want to put it, especially by saying can take on a new significance, meaning that they could just flip it to mean whatever they want it to mean at the time. Is that accurate?
Of course, the feds, I told you, they have this thing where they think, okay, we're going to hire this specialist that's going to interpret their slang, going to interpret what they have going on, what's going on with them. And when I heard you say about me switching cars all the time and none was registered my name, I was ahead of my time. Because, you got a lot of people that would get one car and do all the crime, all the dirt, go pick up their girlfriends and then go do everything in that one car. See, me, I know people used to like materialistic things. So if I had my Mercedes-Benz in the project at the time, and I know somebody that's real cool, laid back out the way, I'm going to say, check this out. Want to drive the car today? Yeah, let me drive. I want to drive the Benz. All right, look, come now. Give me your car, but listen. Because like one of my Benz had mirror tints on. I say, drop the windows down so people can see there's you in there and you good. And I would trade cars like that with different people. So while people be happy to drive your expensive car, your nice foreign whip, you just want something to move around in and go slide and glide. So that was just my way of thinking back then.
Right. Definitely ahead of your time.
There you go.
Okay, the affiant goes on a further state. Although it has been possible to obtain telephone records of incoming calls and calls made from the target telephone, the goals of the investigation have not been achieved. Telephone records only provide circumstantial evidence that the telephone was used and that that contact was made between two telephones. Telephone records do not identify the individuals actually making and receiving the calls, nor do they reveal the nature of these calls. Information obtained from the use of court-authorized PIN registers is limited to identification of outgoing numbers called, and in some cases, the identification of local telephone numbers making incoming calls. The time and duration of the call is also reflected. However, the use of a PIN register does not reveal the identity of the individuals making and receiving the calls or the contents of the conversations. So that answers what I was asking you earlier, that even though I gave this address on an arrest, I'm the subscriber to this phone, how can you absolutely know that I made the call, that it was me, or what my intention was for what I'm saying? So for them to press the point that they needed these calls and then come back and say, but it still doesn't give us what it needs, is ridiculous. And if you could expound for a minute on how unfortunate it is and how a lot of people that's generations under you or even me don't even realize how tricky and what type of tricks and traps are set to build these cases upon them.
See, this is what it is. That's why a lot of people get throwaway phones.
Okay.
But with the government would try to do stuff like this. They'll know, okay, the phone not registered to him, but we hear him on here. So now, if he, of course, we go, man, I ain't me, that phone in my name. So now they're going to get a voice analyzer. So they're going to get somebody in court to say, this voice here matches this voice. This is him here, this is him here. And, that's how they, the jury, they just sit there, they don't really know no better, know what's really going on. So they would just be like, okay, so we got that going on, this person up here with this suit and tie on or this dress on saying it's him, sound like him, it's him, y'all. And so they go in their room, they gonna huddle up, yeah, that was him. I know that little, you dig, you heard me. I know that little country accent he got.
Wow.
That's what they do.
Okay, so the affidavit goes on to state, CS1 has advised that Williams and his other associates will not deal with individuals who are not known to them. Your affiant believes that there are no undercover agents/officers who can infiltrate the conspiracy at a level high enough to identify all members of the conspiracy or otherwise satisfy the goals of this investigation. Your affiant believes that it would be too dangerous to even attempt to introduce an undercover agent/officer into this conspiracy. Based on my experience and the experience of other special agents of the FBI, your affiant believes that the use of search warrants would not provide evidence sufficient to determine the full scope of the criminal activity, identify co-conspirators, or show the various methods used to purchase, transport, distribute cocaine, crack cocaine, and heroin, or the location of the profits and laundering of drug assets. Your affiant believes that search warrants executed at this time would be more likely to compromise the investigation by altering the principles to the investigation and allowing other unidentified members of the conspiracy to insulate themselves from detection. Insulate stood out to me as in to really step up your defenses where you already had a group of friends who knew how to protect themselves. And from what I've read the entire time, and especially at this point, it appears to me, and I'd like to know if you agree, that your circle of friends, even though it wasn't an organization or this conspiracy to have criminal enterprises, they're saying that in your friend group, it was tight and it was filled with loyalty. And that in this day and time, that's something that's very rare or maybe almost endangered or extinct. Would you agree with me on that?
Yes, let me elaborate on something you passed up, and I'm pretty sure the people will want to know about, man. Seeing like you're trying to rush your job. Anyway, the part where This is how undercover agents gets are able to infiltrate drug organizations. When someone introduced them, oh yo, this my homie, or this my auntie, or this my people here, man, good people. They want to score 2-3 kilos of heroin, or 2-5 kilos of cocaine, whatever. So the average person is money hungry. They want that sale. I ain't what's up with them? How to, with us, it was like, and I used to always tell people, man, I don't want to meet none of your friends. I don't want to meet nobody. And then we had already learned from Killer Stone how the feds was moving a little bit too. So, and then you could smell. And our time we could smell the detective. It was goofy and sloppy back then. But nowadays they kind of a little up to par with it. Trial and error, I guess. But yeah, it's only Hot, Blabber, myself that hustled right there. So it was 8 people on my case, and nobody told them my case. Everybody pled guilty. And like you said, that is rare. But at the end of the day, the informant knew, because they really wanted their agent in too, because once they got their agent working in it is better, because now because when you got an informant working for you, well, for them, they kind of don't trust him, because informants gonna do drugs, they're gonna do different stuff that will cause the investigation to be terminated or mess up. So they would prefer to put one of theirs in if they could get them in there. But he must let them know, nah, we ain't gonna be able to do that, boy. They ain't stupid like that. Because we wasn't hurt for money. We was getting money from selling drugs, robbing, taking hits. So we getting money all around the board, so we wasn't hurting. That's why I didn't really care about hustling, standing in a project to hustle. Because I kept money. My motto always been from then to now, as long as they print money, I'm going to get some money. And now I'm getting the money the legal way, but as long as they print, I'm going to get it. So that was never an issue for us, getting the money. Yes, ma'am.
Okay, thank you very much for that.
You're welcome.
So we go on to the next section, which is minimization. So in this section, they start applying and attesting that all interceptees will be minimized in accordance with Chapter 1 in Section 119 of Title 18 United States Code. The interception will be suspended when it is determined through voice identification, physical surveillance, or otherwise that neither the individuals identified in paragraph 2 above nor their associates, when identified, are participants in a conversation unless it is determined during the portion of the conversation already heard that a conversation is criminal in nature. Even if the individuals identified in paragraph 2 above or their associates, when identified, are participants in a conversation, monitoring will be suspended if the conversation is not criminal or otherwise related to the offenses under the investigation. But even to determine if the conversation is criminal or not criminal, it still seems like, even though they can get an order for it or permission to do it, it seems like an invasion of a person's natural rights to listen to everything that I have going on for you to determine was criminal or was not criminal by your perception. So do you agree with me that this extremely intrusive and unnatural, especially being that they keep saying it's failing?
That's why they asked for 60 days. So within that 60 days, whatever they could come up with, you know what I'm saying, they could gotta just shuffle through the stuff. So of course I feel like it ain't right to be. I know this here, they tricked us. People just always say back in the day, oh, they can't tap no Franco phone. That's a phone they can't tap. Anyway, yeah, I feel like all that stuff is illegal and unconstitutional. But you know what? A lot of people don't realize this. And I want people to realize, pay attention to this. Whenever the feds, be it ATF, FBI, whatever federal government come to kick in the house, come to arrest someone, you're going to always see a police, the state police or sheriff or somebody with them. Because the feds really don't have no jurisdiction. That's why you're gonna see they're gonna go to the state judge and get a authorization to sign off on to run off in people property and people's spots.
Okay.
Little
That
gang.
makes sense now, yes. Okay, so it goes on to state that intermittent spot monitoring will be utilized to ensure that a minimized conversation has not become criminal in nature. Monitoring personnel will be instructed to minimize any and all conversations related to privileged attorney-client, husband-wife, doctor-patient, and clergy-parishioner communications should they arise. Your client is aware that the aforementioned individuals that have current charges pending are represented by attorneys. Your client will ensure that all monitoring agents officers are aware of the privileged relationship between those individuals and their attorneys. Communications which concern criminal activity not outlined in the affidavit will be intercepted, and notification of such interception will be made promptly to the United States Attorney's Office. So I might be redundant, but again, they're listening on the phones. They're stating here that they're going to minimize things that they shouldn't be listening to. Now we come to another level for me, which is a vulnerability or invasion of privacy, because you listen to my doctor and I, in my most intimate, private parts of my life, and I don't know you're listening to me, I don't know anything about you. We have instances of crooked cops, rogue cops, people actually harming people and having this vendetta against you. In hindsight, learning that they knew when you was going to the doctor, what you were going to the doctor for, like what you and your attorney was talking about. Did you have any kind of thoughts like, what if somebody would have went rogue? Like they get all the information they can to kind of control the narrative, control the situation, and even if they wanted to cause harm to the people that they're monitoring. So what are your thoughts on that? And have you ever heard of any instances where they kind of rough somebody up or harass somebody because they were invading their privacy beyond a legal guise?
Of course, the feds do that all the time. That's how they first get you to first cooperate with you. They're gonna put up on you. Some might beat you up, rough you up. Some gonna scare you, threaten to lock you up. If you're married or have a girl, children you're living with, some of them be like, "Man, I don't want to go to jail. I don't want to leave my woman. I don't want to leave my children." And that usually how they trap the people. Starting out, and once they got you, then they go and start putting their plan together.
Okay. It's deep. Okay, so the affidavit goes on to state, on January 22nd, 1998, a review of the FBI and Drug Enforcement Administration headquarters electronic surveillance instances revealed no previous applications had been made to judges of competent jurisdictions for authorization to intercept or for approval of interception of wire, oral, or electronic communications involving any persons, facilities, or places specified in the affidavit. And you did just speak on that they did that as a federal level. They have to go to competent jurisdictions to get authorizations. And they're saying that no one had previously done that. Okay. In view of the information set forth above, it is believed that the communications which are the subject of the requested interception will be obtained on a continuing basis for a number of days following the first receipt of the particular communications which are the objective of the application submitted herewith. In order to detect all the individuals who are expected to be involved in the distribution of cocaine, crack cocaine, and heroin, interception for several weeks is expected to be required. Therefore, it is requested that these intercepts not be required to automatically terminate when the sought communications are first obtained, but that this authority continue for a reasonable period of time thereafter, not to exceed 30 days measured from the earlier of the day on which the investigative law enforcement agent first begins to conduct interception under the court's order of 10 days from the date the court's order is entered. So I know that they asked for 90 days, and I see 30 days here, 10 days here. Can you explain that to me exactly what they're stating or further asking for in this section?
They be needing to buy time because
Okay.
it might be a time where we might be like, man, we chilling, there ain't nothing going on. So I remember when they locked us up, it was an old man, cause he said, man, at 3, 4 in the morning, you used to tick me off. I said, what happened? He said, man, it would be my turn to monitor your phone calls, and your phone would ring, and I'd be like, pick it up, pick it up, pick it up, and you wouldn't answer. I'm like, well, you be asleep around that time, man. But they work around the clock. See, people don't know that when the feds on to you, they're gonna have shifts where people gonna be working around the clock trying to find something. So you know how we might be like, okay, in the daytime, I know the feds be out, move around, so I'm gonna move around at nighttime. Them people around the clock.
Wow. Okay. It goes further to state, pursuant to provisions of Section 2518(4) of Title 18, United States Code, the court may, pursuant to a request of the applicant, direct that a communication service provider, landlord, custodian, or other person furnish the applicant forthwith all information, facilities, and technical assistance necessary to accomplish the interception obtrusively. The assistance of the prime co-personal communication are required to accomplish the objectives of the required interceptions. It's saying that it's required, but I believe in part 1, they said or stated when they first went to Prime Code that there was a technical issue that was preventing them from getting full access from the beginning of their request to Prime Code. Do we remember that?
Yes.
Okay, so they continue to waste money getting these records from Prime Code that they couldn't get full records from. Is that correct?
I don't know, but I know this. Like I told you, I was always told they couldn't tap the Prime Code.
That's exactly what they just said again. So that proved to be true. Okay, and then they further state, check this, reasonable expenses incurred pursuant to this authority, the Prime Code personal communication, will be processed for payment by the FBI. So that's what I'm saying. They continue to waste money. And as you said, they couldn't fully tap the Prime Code phones. Okay. Your affiant requests that the authorization to intercept wire communications apply not only to the target telephone number listed above, but to any changed telephone number subsequently assigned to the target telephone. 504-259-0692. Electronic serial number 001 022 24439 within the 30-day period. It is anticipated, based upon your affiant's experience, that conversations in the premises which are the subject of this investigation, as well as conversations that are background conversations in the place where co-conspirators may be calling from or are called, will relate to the violations of federal law specified in paragraph 2 of this affidavit. It is therefore requested that these background conversations be made subject of this court's order for the interception of wire communications of this case. Wow. So, in my perception, I can go to a baby shower or I can go to a church gathering, and if one of these target telephones is there, whatever I'm saying in the background is now a part of interception and surveillance. So, if my perception is right, can you expound on how association can get you surveilled or under surveillance?
Exactly. Just how you just said, associate. You know how people always say, oh, you guilty by association?
Wow.
So yes. People got to realize when people be like, now the truth told to the joke, a lot of that stuff be accurate, like, and it's sad how they make these laws. We don't know. We depend on the lawyers to help us out, and a lot of the lawyers be failing us. Um, it took a while. Once I got in and started studying the law, I really realized that I did a lot of time when I wasn't guilty for. They charged me with an 848 continuing criminal enterprise. The charge first started out with just this little heroin right here that this guy bought.
Wow.
But then they knew about a lot of homicides, murders, and they knew, like, you know what? This small. We didn't waste all this money on this here, and we didn't really get nothing. So now they came with a superseding indictment and hit me with the solicited to commit murder when I wanted to kill my co-defendant. Kill the drug dealers, and the connect, and 848 because it was Bryce, Blabber, Elton, the dude Byron in the Milf that I didn't even know, never met before, and they had the female from Tennessee who was in college. So for the 848, all you need is 5 or more workers. So they used them as my workers, and none of them never worked for me.
Wow. Association.
Yes.
It's much more serious than people take it to be. Okay, so the last statement in this affidavit is, wherefore, because of the existence of facts and underlying circumstances of the continuing investigation listed above, your affiant admits that the probable cause as stated in paragraph 2 exists. After stating again and again that they failed, they concluded with the probable cause as stated initially exists. And that wraps up the affidavit by Stephen R. Sloat, Special Agent, Federal Bureau of Investigation, United States District, Eastern District of Louisiana. So in conclusion, what I get in the simplest terms is that the interception of wire communications, other known as a phone tap, is what caused the Magnolia Projects to stand still and its legend, or the legendary hot gangster, to be arrested. So can we close with you sharing exactly how both Gangsta and Mr. Williams felt when you realized that after decades of being the object of confusion in the U.S. justice system, that you would be going home to your life as a free citizen, and then how you felt to learn that the Magnolia housing development no longer stands?
Well, first of all, I remember being in prison in the jail, Paris, in Temperman. I got a letter from Glenn Metz out of the Calio Project because he was charged with 848, the kingpin status as well. And he was like, I'm writing you because if my son was locked up, I would want somebody to write him and explain to him the laws of the 848. He said, they don't have an 848 on you, man. You can beat that. Mind you, the 840, the stuff you just read with the guy who's white coming by the little drugs from me, that wasn't nothing. I wouldn't have got no more than 3-4 years for that. If that. So when he came back with the solicited to commit murder, because I told my co-defendant that we're going to kill him. Then he hit me with the 848. That's 20 to life. So now we got him, right? And I'm like, okay, I'm in my early 20s. I could do that. I'm going to plead out. But I remember once I got that letter from Glenn Metz, I had the guy Byron was next door to me. So he knocked on the door, and I come to he said, call Gangsta to the door. I come up, what's up? He said, I got something, man. All this stuff got your name, and he slid it under the door to me. And I started reading it, and I remember asking Bryce, like, about the people in New York, so with the heroin. So as I'm putting stuff together, I gave it to my attorney. I never forget I had an attorney name was Arthur Buddy Lehman. I hired the father. He's a fighter on all the mob bosses' cases. He was a big dog. His son was fresh out of school and college, and I said, hey, have you ever worked on a high profile case? He said, no, but my father have. Any question, I'll ask my father. I'm like, oh man, I'm in trouble. So when he come to visit me, I had called baby them, they paid him. So when he come to visit me, I give him some paperwork, like, listen, man, show the prosecutor. No, I'm not. I mailed the paperwork to him, and when I went on visit, I brought my copy, and I was like, man, you know, I'm not the boss of this case. We all were just equal, like drug dealers. They work for me. He said, well, I'll let her know when we go have dinner tonight. I'm like, dinner? What the world? So when he come to visit me, he said, those his exact words. The prosecutor name was Mary Jude Darrow. She made it the DC of my case in the 7-1 soldiers. He said, well, Mary Jude told me to tell you, stop trying to be an attorney and come on and plead guilty. I'm like, what the world? Why would you come and tell me something like that? So when that man said that, what stuck in my mind was when I go have dinner with her tonight, and when she said stop trying to be an attorney, that let me know, man, they working together. They'll just sell you out. And for a long time, as I started reading and studying that 848, that CCE, there is no way they would have convicted me if I went to trial. But a lot of us be like, man, I'm just going to plead. I ain't going to go to trial. I'm good. I'm going to chill. I'm going to tap out, take the little 10, 15, or the 20 years they're going to give me. I played out while I was waiting to get sentenced. A guy named Robert Moody from the 11th World War, a Wyoming blabber in the temperament, and blabber was talking about whatever he was talking about. And by me being the head of the case, they enhanced me. It gave me life for 2 homicides. I was never indicted or charged for them. Enhanced me, give me a life sentence. Our case got overturned. Blabber went back to court. They reduced Blabber's sentence. I went back 2 years after Blabber. They gave me life again. So I've never had a fighting chance. Them people just give me life, like, whoa, hold on. What I'm fighting? What I got? You know, I ain't go to trial. I don't have nothing. How y'all throwing a life on me? The judge say, this is in my sentencing training. The judge say, I understand I have the discretion to give you lesser time. But with that being said, I'm going to give you life again. By the preponderance of the evidence, that was his exact words. But I always had a outside support. My mother, Slim and Baby, so they held it down for me. Anytime I told Baby I wanted, him and Slim, I needed money for an attorney, I would put a little extra on it, you know, just in case. But at one point in time, I just thought I was going to die in prison, because it was like every law that came out, it applied to me. But then, because of the 848 I was charged with, they said I couldn't get it. They give it to my co-defendant. I couldn't get it. It went to Trump came in, when he signed in 2018, in December 2018, that First Step Act under the compassionate release. You could file, everybody would file these motions, extraordinary and compelling circumstances that back in the day we was bound by the guidelines, but now the courts have a right now to come and reduce our sentence due to us programming, staying out of trouble, being incarcerated a long time, and that's what helped me. So a lot of people need to know, when they be out here hustling, throwing rocks at the penitentiary, thinking they gotta make it money, and they ain't getting them about $2,000-$3,000, thinking they balling and got the little money in their little sock or the rubber band and got it tucked, put up. Man, playing with them people, you gonna need some money for lawyer fee to bond out. And them lawyers, they do not play fair. A lot of lawyers, not all of them, but a lot of them, they gonna do favor for favor with them prosecutors. They do that. They gonna work it out. All right, look, I'm gonna give you him, I'm gonna give you this, and you. That's what they do. They be laughing and playing, because you gotta understand this. All of them, because I had a person I knew that went to Tulane University. So a lot of them go for law. So you got something that got to take the bar. So they all be in college together. friends, cool, you know, rubbing elbows, just when they're at their courthouse, they're going to duke it out a little bit. And afterwards, they're going to get them something to drink. They're going to hang out, you know, and that's just what it is. And like I always tell people, when I was in the streets, running them streets, everybody in the streets that I look up to was gangsters, hustlers, moving around. So they just taught me how to be a good criminal. But what the at-risk youth have now that I didn't have, somebody like me, that bench roll that could show them like, hey, you don't want to play this game. 2 things at the end of the day that waste you: death in prison while you hustling. My weakest moment in prison was when Katrina hit. I'm used to seeing that in another country. So I'm in a penitentiary. I was in U.S. Penal Query 5B. The dorm 5B I was in. I think that's the yellow side. Blue side? Whatever, but I think it's the blue side. Anyway, I was in 5B in U.S. Penal Query in Pioneer, Kentucky. And when Katrina hit, so, you know, I'm like, what the world? The city underwater, man, I ain't never seen no, but that stuff just blew me, you know. And then on the news, they talking about refugee. What the world, man, my people know. I was ticked off. I'm in my cell crying. The brothers tell me be patient. And man, that was like a moment that I felt like I failed my family. Like, you know, because we all, even though we run the streets, we all want to protect our loved ones. And that was one of the moments where I was like, man, what I done messed up. Yeah, so while they got their freedom, they better cherish it. And if you're hustling, whatever you're doing, take that money, invest in something, get up out the game before it's too late. And that's all I got to say for right now. Wow. I'm free, baby. Free at last. Free at last. Yeah, that's a fact.